The difference between income from work and veteran benefits is that benefits are compensation for injury and loss. They're not compensation for work you did. Right. Military retired or retainer pay is compensation for keeping you on at a smaller salary just to keep you around in case they need you. It's not compensation for money, that you've set aside for 20 years of service in the military. It's not magic. It's a lower level of pay for your availability if we need you to go back in service and do the job.
Lemley versus United States.
Yeah. So this is, thank you, Don. That was a very good injection there. The point is that every one of these things that we're looking at is protected by federal law that says it belongs to Congress. It belongs to the departments of the federal government, and it belongs to the federal courts. There's no point in time where the state courts would have jurisdiction on the subject of Title 10, Armed Forces of the United States, Title 38, Veteran Benefits. So that's where we're looking to hold the judges accountable. So in the court system, we're suing the judges. Speaking to Congress, we're trying to get them to understand that veteran benefits have never been part of the jurisdiction that belongs to the states. States have never had a right to receive veteran benefits. And if you look at, case law, we can certainly point out that the state is not an intended beneficiary of Title 38, has no right to the money. And then,
so specifically under 38, so people can see it for themselves, I can actually bring this tab up. Payments under Chapter 15 of Title 38 U.S. Code, including accrued pension benefits are not considered. They're excluded from income. Let me bring that up real fast. Hit the right button, Steve. Have one of those days. So you can see right here, this is what you're talking about.
What part of the CFR are we in? 38 CFR?
Yes. We are specifically 38 CFR 3.272, exclusions from income. Now, what that means is not even the IRS can touch this. So the family courts can't touch this.
It states it right on the website, the IRS website.
Yes.
Right there. Can't touch it.
Yes. Yep.
So in the cases that we're bringing, back in the day, Rose versus Rose, everybody's heard of Rose versus Rose. Raise your hand if you have. Rose versus Rose.
Yeah.
Okay.
They love that one.
So they live on that. At that point in time, the Supreme Court of the United States said that there were 4 statutes looked at: the apportionment statute, the anti-garnishment statute, and the jurisdiction statute of Title 38, and the little one over in the corner, Section 659 of Title 42, which is part of that Title 4D thing. And they said, well, this one doesn't preempt state jurisdiction, and that one doesn't preempt state jurisdiction because they weren't really about jurisdiction.
Right.
Section 211 did not happen to give the administrator of the VA exclusive jurisdiction. It said that if the administrator makes a decision, then nobody can interfere with that in the federal courts. But it said that these decisions cannot be reviewed by any other official or by any court of the United States. The court said that only applies to the federal court. So what they said is that current federal law at that time did not happen to make veteran benefits exempt from state jurisdiction. But they've never been part of state jurisdiction, so what's the problem?
Right.
That opened the door for the state courts to go after veteran benefits like it was going out of style. However, Congress was already working on a bill to provide judicial review through a federal court when a veteran's claim is denied. But they also said in order to stop all the rampant attacks and expenses and litigation and all that other stuff, they have to just say, only certain courts can look at veteran benefits in a certain way. And the idea was to protect beneficiaries by making it absolutely clear states have no authority. So when they changed the words of Section 211, they removed that phrase of the United States, and they made it clear that the administrator shall decide. Shall means shall decide only.
Yep.
All questions of law and fact that affect the provision of benefits to any veteran, dependent, or survivor of the veteran. What that means is that if there's any question about the distribution of benefits between the veteran and the dependents, it belongs to the administrator of the VA. And then a few years after that, in 1991, they changed Section 211 to Section 511, and they changed the word administrator to secretary. So from 1988 forward, from the Veterans Judicial Review Act forward up to now, states have not had any jurisdiction to make any kind of a ruling about veteran benefits. And when they talk about military retired pay and then yada, 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 and disability pay, they're corrupting the law. And they're corrupting the law so they can get paid by it.
Mm-hmm.
So that's what we're talking about. Section 511 controls jurisdiction on veteran benefits. And Section 511 pointedly says the secretary shall decide all questions of law and fact. There's no room to question that. That's the law itself. The CFR is written by the VA in response to the law. Congress changes the law. The VA changes the CFR. And they're supposed to be the same. But current VA policy is to allow garnishments even though they know better.
For the layman out there, what Bob is talking about regarding the word shall, in legal terms, in a legal document, shall means this is not a negotiable thing. You shall do this. It is a command. And anytime you've got shall in a properly rectified legal document, that's it. There is no other, that's the course of action you must take. You shall take this course of action.
Right.
Well, Congress wasn't just ordering the secretary or the administrator at the time to decide those questions. Some people say that it was to get them to decide on alimony and child support cases. That's not it. VA benefits and alimony are two different things. And there's no provision in Title 38 for alimony. None. Former spouses never have a right.
All right. You're using alimony. We use the word Alice isn't horny anymore money.
Hey,
This is a dry
We have to laugh about this stuff because we've been through so much of this, and I know you guys have as well. It gets really intense and it drags you down to a. But when Pop and I started this, just as a minor segue here, when Pop and I started this, I was staying at his place, and we would get so deep into the weeds on all of this stuff that you're talking about right now that we would put a fire in the fireplace in his living room and both just sit there and not talk and stare at the fire for like 3 hours.
Yeah.
Because it was such a heavy topic.
Well, there was beer too.
There was also beer.
Yeah.
And pizza rolls.
Yeah. Yes. Got to have those.
And, like the front of the courts and stuff like that here in Michigan and, the state court administrators, it blows me away too, because on the sheets that they send you, it says VA benefits. And I think it goes back to the Rose case, the USF, PA 1408.
USFSPA.
There you go. So it kind of gave them that, it lifted this bar to where they just went, well, we can take all VA benefits now. And that's just simply not the case. And most VSOs don't know.
They don't know.
The VA already has an Article I tribunal set up. So it goes directly to them.
Hang on. An Article I tribunal, explain what that is.
Yeah.
Well, it's not a Judicial 3 entity. It's I want to, Bob, you might be able to help me out with this. I'm still learning a little bit about that through the VA.
Say the term again.
According to Article 1, Section 8 of the United States Constitution, Congress has the power to create courts that are lower than the Supreme Court of the United States. That's an Article 1 court.
Okay.
Most of the federal courts are specifically Article 1 courts. There are a couple of minor courts that are tied in under Article 3, but Article 3 is the Supreme Court itself and the hierarchy of our court system that leads up to the Supreme Court, because in terms of courts, they're the highest court in the land.
Right.
But just think what you're saying here. Congress set up all of these, level 1 courts, which are literally just a fireworks show of cluster fuckery, so they could just fuck us over 3 ways to Sunday.
Right. So when this stuff goes,
Congress did not create the family court.
right.
Somebody created that cluster fuckery, and I want to see them get punished.
Watch Grunt Speak live every Tuesday and Thursday at 8 p.m. Eastern. And if you want to join Pop for Supporter Sundays, go to redonkulous.com/donate and make a monthly pledge. A link is in the Meat Gazer box.